In the last module, we discussed copyright protections. The reason for that discussion was to help you understand what rights you initially hold to the works you create, because when you publish, you'll often be transferring some or all of those rights to someone else. In most cases, that someone will be the publisher of a journal or a book. As a reminder, the content contained within this module is informational in nature and should not be construed as legal advice. To publish, the method through which you transfer these rights is typically through a publishing contract, sometimes known as a publishing agreement. This contract lays out the terms to which you agree in order for the publisher to publish your work. Broadly, it will detail the rights that you assign to the publisher, either exclusively or non-exclusively, and the rights that you will retain. Today, we're going to focus on publishing agreements for academic journals. There are many other possible types of contracts, such as contracts for monographs, magazines, or online publications. While there will certainly be overlaps between different types of publication contracts and between different publishers, each will be somewhat unique. Before you seek out a venue for publication, you should consider which of your rights you would like to retain. The easiest way to do that is to think about what you might want to do in the future. For example, you might want to share your published work with your colleagues or your other stakeholders, archive your work in a repository, post your work on an academic social network like ResearchGate or academia.edu, use your work on your personal website, assign your work as a course reading, reuse charts, graphs, and images from your work, use parts of your work in your dissertation or thesis, submit your work as part of a textbook or a compilation, or even to fulfill grant funder mandates. Remember the bundle of rights that a copyright holder can exclusively exercise that we discussed in the last module? These are all rights that you, as a copyright holder, may possibly be asked to assign in a publishing agreement. There are three main ways that publishing agreements operate. In the first scenario, the publishing agreement may require that you transfer all your rights as the copyright holder to the publisher. In the next scenario, the publishing agreement may require that you transfer some of the exclusive rights that are granted to you as a copyright holder, but allow you to retain the right to exercise others. And finally, the publishing agreement may ask for a non-exclusive license to publish your work, allowing you to maintain the copyright ownership. There are a number of common sections that you'll encounter within a journal copyright transfer agreement. It's likely that you'll find a copyright section, which provides an overview or a summary of the copyright ownership once the agreement is signed. You'll also see a section on retained rights, which explains any rights that the contributor will keep. A section on permitted uses, which detail the ways in which a contributor can use the various versions of the manuscript, including pre- and postprints and the final published version. There will typically also be a section on allowable uses of smaller, specific pieces from within the work, such as the abstract figures, images, or data sets. Often, if the copyright of the work is first held by the government or an employer rather than the contributor, there will be applicable sections explaining the distinctions of the copyright transfer agreement in those scenarios. And of course, you'll also encounter a final section to be signed and dated to acknowledge acceptance of the contract. Like I mentioned earlier, there are countless variations that can be found within the details of these contracts. That's why it's very important to carefully read through the agreement before you sign and, if necessary, for you to consult with legal counsel if you have questions or concerns. Something to consider is that to publish your work, publishers don't actually need to be assigned the exclusive full rights to your work. In fact, all they really need is for you to grant a non-exclusive certain set of permissions, like the permission for the publisher to reproduce and distribute your work. Publishing contracts can be confusing, and sometimes it is tempting to simply sign the agreement without considering your rights. However, you can negotiate if you choose to do so. Even if you don't, it's still important to read your agreement carefully to understand what you can and can't do with the work. In the next module, we'll discuss negotiations and addendums for publishing contracts.